It's my pleasure to welcome everyone to the Management Labor Advisory Committee meeting on October 20th, a special afternoon edition of it. I'm Patrick Priest, the Management Co-Chair, and I'll be chairing the meeting today. I am welcoming a hearty few that are on site here. Most are online, but I will turn it over to Administrator Van Winkle to make sure we have a quorum.
Yes, I've marked everybody as they've come in, but I will do the official roll call. So we'll start with management. So Patrick is here, and I see Tammy. Good afternoon. I almost said good morning. No, it's official afternoon. And Sarah is here. Let's see, John, are you on? And let's see, and Lynn. And then for labor, Matt, I see Matt, and Jill, and Marcy is here as well, and Margaret and Scotty that was out, and Andrew is giving his regrets for not being here today. He's at a conference, but we do have quorum.
Okay, thank you, Teresa, for that. So with the fact that we have a quorum, we can conduct business, and so the first item on the agenda is to review and approve the minutes from the July 28th meeting, our last MLAC meeting, and those were distributed in advance. And I had no changes to it. Were there any changes proposed from what was emailed to us earlier?
We've not seen anything.
Okay.
I so move.
So Sarah has moved to approve them. Do I have a second?
I'll second. Matt, this is Matt.
Thank you, Matt. All right. Any discussion on that? Hearing none, I would ask those that approve to please signify by saying aye.
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 I also vote aye. Are any opposed? Okay, hearing none, we have approved minutes.
Okay.
The next item on the agenda is department updates, and we do have a placeholder for Workers' Compensation Board case law updates, should there be any.
There aren't any, but I believe that Robert is here if there are specific questions that the committee would like to ask.
Right. I would welcome Robert. I don't know Robert's last name.
Actually, I don't think he's on yet. Actually, come to think of it.
I'm on here.
Robert.
Oh, you're on.
Robert.
Aha, there you are.
Yeah, I'm managing attorney of the board. We don't have anything specific to present in the way of case law updates today. There is the thing that we call the quote MLAC report that we send every 3 months, and that was recently sent, which has a detailed summary of court and board cases. And as always, we're happy to answer any questions, as Ms. Van Winkle said.
Right. Are there any questions from anyone on the committee?
I have a quick question. Yeah, it's a question for Teresa. Teresa, were the case notes or the MLAC update distributed to the members?
I need to check. If not, we will get that out to you after at post meeting. But I'll look into that right after.
Okay,
I don't recall receiving them either.
Thank you.
Okay, we will get those out.
I would ask, Robert, thank you for attending. Is there anything that we should be aware of that's coming up, looking forward, that would be helpful for us to bookmark?
Well, I was just going to mention there was the Workers' Comp Division conference on November 1st. I don't know how much overlap there is between your committee and that. There may be a few attendees. And I have actually already recorded my presentation for that, which is a 45-minute update of cases. And then that will be followed by a live question and answer session, November 1st at 11 a.m. And then other than that, we've, just done our in-house CLE, and we were, updating our members on the House Bill, is it 4138 and things like that. But yeah, nothing else that I can think of right now.
And I actually can't speak to members in regards to participation in the educational conference. So in the materials that Brittany sent late yesterday afternoon was an attached email given to, it's an email to me from the Workers' Compensation Division. MLAC members do have a complimentary invitation to attend, and so the instructions were in the email, but if you'd like that email again, we can send that out. And you can attend for part or all of it. There's different pieces of it. I don't believe the agenda has been published yet. I'm looking over at Kara. Is in the registration, okay. I haven't looked at the website yet, but I can send that out as well. Actually, during the meeting, I can also put that in the chat as well. That's probably the easiest way to get it out to everybody.
Okay, thank you. Thank you, Robert, for attending, and it sounds like maybe it would be nice if you came to the next one, and because I don't remember receiving the updates either. So I think there could be questions that come once that's distributed. All right, the next item on the agenda is WCD rulemaking update.
Yes.
Are there?
Yes, actually, there are a couple of activities. So earlier in the week, there were two public hearings on two sets of rules. The first is amendments to existing administrative rules regarding self-insurance security deposits. The rule has been filed primarily to ensure appropriate security deposits by self-insured employers and self-insured employer groups are available to pay workers' compensation benefits in the event that the employer or group defaults or is unable to make payment. The second rulemaking is for permanent rules. These replace temporary rules that were adopted in June 2022 to bring the rules in alignment with the Oregon Supreme Court's decision of Johnson versus Safe, which I know we had discussion on earlier in the year, just kind of an explanatory of what those temp rules look like and such. So public comment for both of those rulemakings are open until October 21st. There's also an upcoming advisory committee meeting on November 30th at 1:30 p.m. This is for the annual rule adjustments for workers' compensation, medical fees and payments, medical service interpreter services. And I will put a link to, right now, so the link I just sent out is a link to the division's rules page. So that does include information on the current rulemaking, recently adopted ones in the hopper, and then also the lovely calendar that Fred puts together in regards to rulemaking activity for a calendar year. So that's all I've got there.
All right, thank you. Are there any questions for Ms. Van Winkle regarding her update? Okay, hearing none, we'll move forward to the next item on the agenda, which is the report from the subcommittee on workers continuation of care, and I did not receive any report. Was there a report that was submitted for this meeting?
No. So according to the co-chair's memo, today's purpose of this agenda item is to give an update on what is happening with the subcommittee and discussions happening there. And so Matt and Sarah are as the committee representatives
Are ready for that. Yep. I did attend just the last meeting and got a little flavor of it. I guess I'll turn it over and I'll let Sarah go first, give an update, and then I'll let Matt follow, and whomever wants.
Okay, thank you, Patrick and the committee for allowing us to serve on the subcommittee. I think it's been I have enjoyed the process. And we have a report, thanks to Teresa and team, kind of a breakdown of what we've done thus far. We've met 4 times since August, and we've received a lot of input from stakeholders on both sides. We've received input from medical providers, from MAC, the Medical Advisory Committee, managed care organizations, safe employers, attorneys, and labor representatives. So we feel we have a breadth of information and input from all involved. And, we're still sorting out feedback and where we're at. Our next meeting is Friday, October 28th. So next Friday at 10 a.m. if anyone wants to attend that. I'm happy to report that we have refined our problem statement. And this is hot off the press. And it looks like it might go back to stakeholders if we can't come up with a solution by our November 10th meeting to deal with our refined purpose, which I will read. The refined purpose of the subcommittee is to recommend solutions so that all workers, specifically workers with open-ended time loss authorizations and those who are not seeking treatment, remain connected with their provider and to minimize gaps or delays in treatments when they are off work or returned to modified work. So this does limit the scope and refine our problem statement from what we have heard as what is the problem from stakeholders that have brought forth information for us. Matt, do you want to chime in where I've failed?
No, I think you covered it all. We also did look at how other states are operating around some of this to get some comparators. And it seems we've had an extensive dialogue. And so the next step, hopefully at the October 28th meeting, is we start to get some proposed solution framework presented so that it isn't just we've had a pretty exhaustive dialogue on it. And so moving forward to get some broader ideas, or probably more defined ideas on potential solutions.
There is some ideas that have been brought forth as solutions, but they don't seem to be in agreement. So we're just looking for further the stakeholders, possibly, if we can't as a group find a amenable solution, that stakeholders will be tasked with going back and through a defined period, make a full recommendation to MLAC as to the solution. Do you feel that's correct, Matt?
Yep, that sounds good.
And we welcome input. We welcome thoughts right now from the full MLAC board. We would love to hear from you. If you've been able to attend, I know some of you have, not if not all, some of it. We appreciate your input today and your questions, so we can go forth. And we do understand the November 10th deadline, and we would love to meet that if possible.
There is one hand raised. It is Tammy Bowers.
Sorry. Okay, since she asked for input today, I wasn't sure if I should say anything today or wait and attend the meeting on the 28th. I have missed some of the meetings. I was out of state celebrating my 40th wedding anniversary. I'm truly that old, but anyway, so Sarah, you made the comment just now that the stakeholders and both sides are not really able to come to an agreement, and so is that why you are maybe wanting to task the stakeholders to meet together and come to an agreement? Is that what I'm hearing you say?
Yeah, the solutions, and they have changed over time based on input from stakeholders and groups and advisory committees, which all that input has been extremely valuable. It doesn't seem that stakeholders are in agreement on what would work. And so, yeah, that's kind of where we're at.
So can I ask, I don't know, the labor side and maybe all the attorneys on here, I counted, Margaret and Keith, Elaine, and Giovanna, and I think Kevin. Yeah, okay. So I have a question very specifically about the B9 letter, because what I see the problem is that, an injured worker doesn't seek medical care. And so they receive the B9 letter and they reply, yes, I'm still having problems and I plan to seek care. And then 30 days later, there's still no appointment scheduled. There's still no care that has been obtained. And so another B9 letter is sent. And once again, they say, nope, I'm not better and I plan to seek care. Is there a way to solve this problem by limiting the number of times they can do that? Because they can just keep doing that for several months without actually seeking medical care. And to me, that's the problem I see over and over and over. Can a very simple solution kind of correct this? Because there's no way we're going to correct, or there's no way we're going to fix the doctor shortage in America. That's not what we're here to do. So I guess that's my question, and maybe that's something that should maybe go more to committee. But I'm wondering from the attorneys, would that be an easy fix?
I'm not one of the attorneys that you mentioned. I don't know. Are there any there's lots on the call.
Yes, there
I
are.
guess.
I will
there are some
mention
on
from the,
committee and off.
well, Patrick, from the subcommittee level, we haven't explored that as a solution. It's something we certainly could explore, and, you know, cutting off the, you know, we've been referring to it as the bug letter at the
Yeah.
subcommittee level,
Yeah.
but I believe that's what you're referring to, right, Tammy? The
Yes,
bug letter.
same thing, yeah.
And it is been talked about as a tool in the basket of tools and how to deal with issues. And it has been brought up that this isn't an effective tool in some cases because it's punitive and it really isn't solving the problem. And people aren't getting better and getting the treatment that they need.
How's that punitive? I guess that I've not seen that. I've not experienced that, because usually an injured worker will write back and say, yes, I'm still having problems and I have an appointment scheduled in 6 weeks. Great,
Yep.
that
So,
answers our question.
I definitely think it's worth exploring. Are you thinking maybe limit the amount of times that the bug letter could be sent before it's then automatically closed?
Yeah, before
Is
they
that-
actually, I don't know, you know, I guess that's something we would have to brainstorm. I was more asking if that would solve this problem, because the problem is, you know, that language, they don't have to actually schedule an appointment or see a doctor. They just have to reply that they want to see a doctor. And they can just keep replying with that. And that's what I keep seeing. That's what I keep running into, that no, they're not better and they want to see the doctor, but they never actually call to schedule an appointment or go into the doctor. And so, you know, maybe just some little something in there, or, you know, they can, after 3 consecutive ones with no medical care, then closure is appropriate. Because I think the rule says you must close, but yet it doesn't say you must. Oh, good. Keith's going to chime in. I'm going to mute myself.
Sorry, I didn't expect to talk today, and adjust my lighting here. I mean, those are the types of things that we've been kind of suggesting, is that there's existing tools, and to the extent that existing tools aren't sufficient, let's talk about those tools. Let's talk about something tailored to what we're identifying as the problem. And our main objection to kind of a 30-day limitation on work restrictions is that that's punitive in a lot of ways. And we think that the scope of that proposed solution is far broader than the problem that's being identified, because it applies to every injured worker, not just the ones who are missing their appointments or slow to reschedule or things like that. So I think for our part, we're willing to discuss more tailored solutions. And I think what you're describing is in line with something that would be more tailored to the problem of people really dodging the doctors or just being completely lackadaisical about follow-up. You know, we don't support that as a concept either. You know, we don't want to see workers languishing either. So, but that would be more in line with kind of what we would envision, I think.
So just to be clear, the subcommittee has not put a 30-day limit as a solution, and we have just explored the solutions that are out there, which that has not been to the subcommittee as a 30-day hard deadline on having to see a doctor.
Yeah, it keeps coming up, but I understand it's not officially part of the discussion, so I don't know where that leaves it, but it does keep coming up in terms of there being a hard deadline, and that we've expressed our concerns about the hard deadline on the work restrictions. So.
So can you add that for the discussion on the 28th, or do you want me to come and suggest it, or can I just suggest it right now?
No, I think it's worth talking about. That's what we're looking at, and I think Matt and I agree that, you know, we've heard lots of information, and now with a refined purpose and statement, we're hoping to address the problem with a solution.
Thank you.
Yeah, I agree.
Well, thank you for that discussion. You know, the one thing we haven't talked about yet is there is a refined problem statement or statement of what you're working on. And there wasn't a lot of discussion on it. You read it aloud. That was the first I heard it, Sarah. It sounded fine to me, but I wanted to open it up for discussion. Is this committee agreeable to that statement? That seems very pertinent. Are they working on the right thing?
I believe we are. We collaborated on it and we're in agreement before it was sent back out to Teresa and team to move forward on. And this will be our focus on the 28th as well, our refined problem statement looking for solutions.
And I would support the statement because as the subcommittees work, the scope can be kind of broadened rather easily to access of care. And like Tammy mentioned, well, we aren't going to get more doctors, and that hasn't been necessarily where the committee should be focusing. We're looking at more of how do we keep these workers connected with their recovery process and their providers. And so at times the discussion is easily taken outside. So refining this statement, I think, is very helpful.
Again, it's a good one to me too, but for those that maybe didn't go to the subcommittee, are they also, does anybody, I guess rather than agreement, does anybody want to speak up and say they would like it refined or they don't understand it, or does it seem good? Seems, okay, I'm seeing it seems good. So I hope it'll be reflected in the minutes. I'm sure it will be.
It will be, and actually, we've held off on issuing next week's agenda until after the to have this discussion. And so the verbatim refined problem statement will be on the subcommittee agenda, and we plan on issuing that this afternoon.
All right, well, thank you for that. I guess we will wait until our next MLAC meeting to hear an update, and the October 28th meeting is a public meeting, so anybody on this call and others, you could tell a friend that may be interested and they could attend to. So,
Patrick, just to finalize that, just
sure.
for the full MLAC committee to understand, our original charge was to provide a solution by November 10th. I think we'd still like that if we can, but if not, just it might have to go back to stakeholders with a defined time period to bring it back to the full MLAC board.
Okay, thank you for that clarification. All right, if there is nothing else on that topic, I will move on to the next section, which is presentations of 2023 legislative concepts. And it does, and my agenda say pending stakeholder
yes, and
availability.
I will explain this because this is the first time I know a number of you have seen this, and this is the kickoff for review of legislative concepts for the 2023 legislative session. So by tradition, what we do is when we, the department, are aware of concepts, we place them on the agenda. So you notice that today this also includes the 2 legislative concepts from the Workers' Compensation Division, because yes, agency concepts do have to be vetted through MLAC as well. It's not just for legislators, stakeholders, et cetera, there. So I am not sure if all of the various parties are going to be here today. I know that WCD is here. Sally's ready to go until she's down. So the division will be first. So we try to have this information, and we also encourage stakeholders to do this process and be ready to do their presentations earlier than later. So for example, right now you'll see it's in the legislative council form. There's not a bill number assigned to it. That happens later in the year, early January. So this provides as much time as feasible for all of you to receive information, for stakeholders to provide feedback, and when there needs to be amendments, time to take care of that in alignment with their deadlines. Okay, well, thank you very much for that clarification. So it looks like we have speakers for the first 2. So the first is Legislative Concept 418, Worker Leasing Company Reporting Requirements, and I will turn it over to the Workers' Compensation Division. I heard Sally Cohen was on the call and was going to tell us about it. And I see her now. Take it away.
Good afternoon, Co-Chair Patrick and committee members. Thank you for having me here today. I'm Sally Cohen, the Administrator of the Workers' Compensation Division. The division has requested LC 418. This would modernize worker leasing company coverage reporting processes. Many Oregon employers contract with worker leasing companies. These are also known as professional employer organizations, or PEOs. Worker leasing companies do act as the employer of record for their clients' workers. They provide many services, including payroll, benefits, and workers' compensation coverage. Under current law in ORS 656.850, a worker leasing company licensed to operate in Oregon must tell both its insurer and the division when it starts or stops providing workers' compensation coverage to a client. Worker leasing companies report client coverage to the division on paper forms, which we then manually enter into the division's coverage systems. To our knowledge, Oregon is the only state that requires a separate paper-based process for client coverage reporting. So our end goal with this concept is to eliminate this manual reporting process. Instead, worker leasing companies would continue communicating coverage changes to their insurer, and their insurer would report the client coverage data to the division electronically. This is how insurers report data on worker leasing company clients in other states. It is also how insurers currently report policy data to the division for all other types of policyholders. Making this change would reduce administrative burdens on worker leasing companies and the division. This concept is only the first step, however. Rulemaking and technical changes would also be needed to get to that end goal. What this concept does is remove language from existing law, which says that certain coverage changes have to be reported to the division in order to take effect. Coverage changes outside of worker leasing don't need to be reported to the division to take effect, so the current law is an obstacle to allowing electronic reporting of client data. This concept would also remove an obstacle to insurers providing coverage to worker leasing companies using a multiple coordinated policy. Most worker leasing companies have a type of master policy where a single policy is issued in the name of the worker leasing company. Under a multiple coordinated policy model, each client is covered under its own separate policy. So some insurers have expressed a preference to us for providing coverage this way. And in the future, the division does intend to explore requiring use of the multiple coordinated policy for worker leasing coverage. We have reached out to worker leasing companies and insurers for feedback on this legislative concept. The feedback we've received has been mostly positive, but some insurer stakeholders have expressed concerns that if worker leasing companies no longer report directly to the division, that insurers will have less certainty about which clients they are providing coverage for. These stakeholders have offered to put together some draft amendments to the concept that would address their concerns. So we do look forward to continuing to work with them. I'm happy to address any questions the committee may have. And also on our call today is our policy analyst, Aaron Feldman, and he's available for any technical questions you may have about the concept.
Are there any questions from the committee members? Great, I'm hearing none. And it sounds like this affects stakeholders, you know, pretty directly, and they've had comments already. Are there any stakeholders on the call that want to go on the record and tell us what they think? Okay, well, hearing none, I guess we'll find out more later. It sounds to me somewhat of a housekeeping item, but I don't know, we'll learn more when it's presented to us for review, for approval. All right, the next item is legislative concept 419, which is regulatory streamlining, and again, Sally.
Actually, before we go, I see David Berenberg's hand is raised, so.
Oh, okay, all right, David, you came in just under the wire.
I just wanted to very quickly say a thank you to Sally and the division. They floated these ideas in the spring and gave us language as soon as they had it. And it's just wonderful that they've shared so we can work through whatever issues we have, and just wanted to express our appreciation.
That's wonderful. Thank you, David, for that. Well, Sally, legislative concept 419, regulatory streamlining is the next item on our agenda, if you're prepared to speak about that one.
I am. Thank you, Co-Chair Priest, committee members. Again, Sally Cohen, Administrator of the Workers' Compensation Division. We here at the division, our staff, are always on the lookout for laws that are outdated or are inconsistent with current practices that can be addressed in kind of a regulatory streamlining bill. So this time we have requested LC 419. This bill would address needed changes in two areas where we've identified. The first change corrects the reference to the state average weekly wage in the law for fatality benefits. So that law is ORS 656.204, and it refers to a definition of state average weekly wage that is found in another part of the law in ORS 656.211. And this has not been applied in this way, and nor is it consistent with other provisions of the law. So based on our legislative history research, we believe the cross-reference was inadvertently cited to the wrong definition of state average weekly wage when it was added to the law in 1995. Current industry practice follows the definition of state average weekly wage in another part of the law in ORS 656.005. So this legislative concept simply aligns the statute with that practice. The second change in our concept clarifies payment of benefits due to an insurance company's default. Under current law in ORS 656.445, when an injured worker does not receive payment of benefits due to an insurer's default, the division may advance funds to the worker from the Workers' Benefit Fund for the period after the insurer has become insolvent, but before the Oregon Insurance Guarantee Association assumes responsibilities for the insurer's claims. However, the law does not clearly state that this process applies to beneficiaries who are not injured workers, such as spouses and children who are entitled to fatality benefits. This concept would specify that those beneficiaries are also entitled to the advanced funds. So I'm happy again to address any questions the committee may have, and I believe I have some technical experts on the line with me today from our policy unit available for any technical questions you may have.
Are there any questions from the committee? I see Tammy's hand's raised.
It's not a
Electronically
technical.
and
Okay, it is not a technical question though. It's just very, very basic so I can understand this. So you were trying to say that the state inadvertently put the average weekly wage for the state's average weekly wage, not the injured workers 52-week average weekly wage. Am I hearing that right?
No, Tammy, there are actually two definitions of state average weekly wage in the statute.
Oh, and so you're just picking out one of them.
It's pointing to the incorrect citation.
Okay, thank you.
any other questions? I guess any other questions from stakeholders or anyone else on the call on this regulatory streamlining? Okay, you've explained it perfectly, Sally. There are no further questions.
It's all my folks who support me, not me.
Okay, all right. Well, thank you to all that are on the call. All right, well, the next items, do we have representatives?
Yes, I'm going to jump actually down to the bottom to the final item. Oh, actually, Paloma's got her hand raised before I start. Apologies, Paloma.
Yeah.
Thanks, Teresa. I just had a question for Sally, especially since paid family leave is coming online, which of course not your problem, but there's lots of references to average weekly wage and just how the division is going to sort of communicate to employers or employees that you need to go somewhere else to look at a different definition of average weekly wage, or how those two will work together, because there is, if you look for average weekly wage in Oregon, you immediately get the workers' comp division's numbers and definition. So that's my only question.
Thank you, Paloma. To kind of clarify, your question is how will we be communicating this out? And we'll need to talk about that. So our definition of state average weekly wage in ORS chapter 656, it's actually calculated for us by the employment department. So we don't actually calculate it. But thank you for highlighting this. You had mentioned this before. We do know we need to be sensitive to talking about this because there are different definitions of state average weekly wage. So thank you for highlighting it. We'll need to build that into our communication.
Thanks.
Yeah, thank you, Paloma. That was a good question. Any others before we move on to the next topic? Okay, I will defer to Administrator Van Winkle, who's got all the notes about who's here and who's not, so I'll let her.
Okay. So we'll jump down to the final, I listed legislative concept idea of chiropractic physician attending status. We have Dr. Vern Sabo, representative of the Oregon Chiropractic Association. And members, yesterday you were distributed a study and some outcomes, 2 different documents that are specific, their background information on this forthcoming legislative concept, and they are included in the meeting materials on the committee webpage. So I do believe Dr. Sabo is here.
I am.
Well, since there was, yeah, great. Since there wasn't a lot of time to review the material, and I opened them up, there was a lot. I don't know if you mind summarizing or presenting it to the committee since we are running early on time.
Mm-hmm.
Dr. Sabo?
Well, so first of all, let's backtrack to the legislative concept is to return full attending physician status to chiropractic physicians within the Oregon Workers Compensation law. And it's our contention that that will not only reduce costs significantly, but improve outcomes for injured workers with common back and neck and spinal injuries that are non-complicating, which is our forte. Dr. Rosner, epidemiologist, we commissioned to synthesize the existing literature relative to our contention that we will provide reduced costs and better outcomes. And that's not a final draft. It's still a work in progress, but I wanted to give the committee what we have thus far. He's going to also address a 2006 DCBS in-house study of data that was charged by then Governor Ted Kulongowski. And again, as I just mentioned, chiropractors are arguably one of the best, if not the best, at treating non-complicating back and neck and mid-back injuries. I mean, that's what we do every day. And one of the cost savings that goes unrecognized is that in Oregon, we have a broad scope of practice. We're basically a one-stop shop. We, of course, do a consultation and proper history taking, but we do a very specific musculoskeletal examination, very pertinent to back and neck and mid-back injuries. That's our forte. But then we also, when it's clinically indicated, can provide our own radiology, x-rays, read those x-rays, and also refer out appropriately for special imaging when it's indicated clinically, as opposed to ordering it willy-nilly. And that's a significant cost in the healthcare system. In addition to that, it's within our scope to provide all the physical therapies, everything from the physical medicine modalities, of therapeutic exercise, therapeutic procedures, to the adjunctive modalities such as ultrasound and diathermy, low-level laser, E-stem, electrical stimulations of different types, and the whole battery of physiotherapy modalities when they are clinically indicated. And probably what we're, of course, noted for is chiropractic spinal manipulation, chiropractic adjustments, which is arguably has some of the highest quality evidence of its efficacy for low back pain and neck pain of any non-pharmaceutical intervention. In fact, I served on the Health Evidence Review Commission for 10 years, appointed by John Kitzhaber back in, 2011. And it was because of the high quality evidence of what we do that a task force was convened in 2014. Dr. Ariel Schmidt chaired it based on scientific evidence, working with Oregon Health Science University Center for Evidence-Based Policy. We rolled out a proposed new Oregon state policy for Oregon Health Plan patients, Medicaid, that included chiropractic osteopathic manipulation at the top of the heap as far as the best intervention for acute, subacute, and chronic low back pain, mid-back pain, and so forth. And acute being the first 4 weeks, subacute 4 to 8 weeks, and then chronic 8 weeks and beyond. And so that rolled out July 1 of 2016. And the outcomes have been wonderful. I treat Oregon Health Plan patients in my clinic. It's been very heartwarming. And I get a lot of these folks who have had a work-related injury and the access of care issue comes up. It's very interesting. So that's the encapsulation of this legislative concept. is simply return attending physician status to chiropractic physicians.
Thank you, Dr. Sable. I have one question to start is, so you said return status. So at what time was it taken away?
Special legislative session in January of 1989, Senate Bill 1197, removed our attending physician status.
And why was it done at that time? Do you recall what the reason was?
Yes, what part of what happened was, we have, in any profession, you have some knuckleheads. Well, we had our knuckleheads. We had those who would abuse the system. They were a microcosm, and they were well publicized. I think I have 2,000 doctors of chiropractic here in Oregon now, and we had those who abused the system, overtreated, and there were five doctors that were brought up on charges of racketeering charges, and that's because they were charging an additional fee for office visit fee, and also they were captured by the situation where an individual coming in from posing as a patient told the front desk people, there was 5 colleagues that bit and thankfully lost their licenses, told the front desk individual staffer that they injured themselves on the job doing this, that, or the other thing. Once back in the treatment room with the doctor, they'd said, well, you know, I told your staff that I did this, doing this, that, or the other thing on the job, but really, what really happened was I was chopping wood at home. And they sat back to see what the doctor would do. Well, 5 knuckleheads said, well, okay, great. And they went ahead and filed the 827, which is in fact insurance fraud. And they were removed from our profession, and thankfully so. One piece that was very disingenuous was the misreporting of internal safe data, repeatedly voiced by then Senate President, Safe President Stanton Long, that what was told was that to see a chiropractor was twice as expensive as seeing a medical physician. And that's because at the time, their study was 1988, I have it, was the average cost for an injured worker to see a medical physician. Back then we referred to them as family physicians or general practitioners. Now we call them PCPs, primary care docs, was $256 case average. To see a chiropractor, including those who were a high-end outliers, averaged them in, our case average was $706 in 1988. What wasn't said by Mr. Long was that that $256 was just to see the general practitioner, who by and large, most medical physicians, and I have many that I treat and that send me cases, do know hands-on treatments when it comes to musculoskeletal injuries, like back injuries, neck injuries. They do one of 2 things. They write a prescription for medication and or a trial course of physical therapy, usually both. Well, those are direct medical costs. They were direct medical costs back then because it required a medical physician's referral. Well, what wasn't told was that in addition to that $256, the case average for medications was $200. The case average for physical therapy was $550. And the case average for radiology was right at $200. So when you just add those up and you don't include hospitalizations, ER visits and so forth, the case average was a little over $1,100 versus ours $706. But that story was never told. We were just twice as expensive. And as I said, we're a one-stop shop. So it was a misreporting, mischaracterization of data, and highlighted some abusers, outliers in my profession. As I say, 5 were indicted. I have some 2,000 chiropractic physicians in the state. That's what happened. It was a one-day special session. It was a freight train, and we were on the tracks.
Well, thank you for that history. Are
You
there
bet.
questions from the committee members for Dr. Sabo about this legislative concept?
This
I
is
have
Matt.
your hand raised.
Yeah,
Oh, yeah.
this is Matt, and I do have a question. I guess you had mentioned that this was a rough draft. The cost effectiveness, and I was looking at just one of the studies, and that would be Turner, and that is the one that makes the assertion just around better outcomes. I'm trying to get back to that because I was reading as we. Bear with me for a second while I get
Sure.
back to that one. Yeah, so Turner, 2008, it says back injury, work loss claim, disability at 1 year. And it states that chiropractors, there were 5% of the folks who saw the chiropractor on their first visit. So reading that study, Turner, 2008, I guess one of my concerns is the authors of that study kind of point out that they say workers who their first healthcare visit was with a chiropractor did have substantially better outcomes, but then they go on to kind of qualify that it's possible that those workers had different prognostic favorability, and that when they did the study, they didn't really dive into whether or not that chiropractic care is more effective. And so basically they said, we need to look deeper into that. So I guess I do have questions that when Turner's put into that, I understand you're probably not the author of this paper, but it seems like that's kind of an extrapolation to put that table in there and make that assertion when I read what the authors actually wrote in the study. So are you aware, is there like somewhere in there that I'm not reading where they do define kind of that they looked at outcomes based on modality and determined that the chiropractors had this better outcome?
Yeah, no, Matt, I have not reviewed, this is a brand new document. I don't know the statistical competency of that paper. There's many other citations. There's a lot of other research. I haven't put it all together. I will be putting a PowerPoint presentation together that'll hit all the high points, the low points, and the confounding variables and methodological flaws, if there are, and present those. But I really am not privy to everything that Dr. Rosner put in there. I've had a lot on my plate. I haven't had time to go through that, but I will be.
Thank you. Thank you very much.
Yeah, good question. I see Sarah Duckwall has her hand raised.
Thank you, Chair Priest. Dr. Sabo, thank you for your information and your presentation. We appreciate it and hearing what's coming down the pipe. A question I have is what's not working in the system? My understanding is there is no limit to a worker receiving chiropractic care on call.
Well, no, there is. Statutorily, we're limited to 18 visits in 60 days, which for a great majority of injured workers is fine. It's the more complicated cases, many of which can go on as unnecessary and unsuccessful back operations. I specialize in disc herniations. I have a specialized instrument, a flexion distraction table that treats specifically disc injuries. And so we're limited to 18 and 60 days, 30 days of time loss. And after that, if they want to return to us, this is if they're not enrolled in an MCO, they have to have an MD's referral. Finding a medical physician that will actually accept a workers' comp case, I think they're all on the moon because you can't find any of them that will take a workers' comp case. And they run into this conundrum of trying to find someone, a medical doc, that will refer them back to me or back to a chiropractor, and then we lose them. And well, I'll give you a perfect example. There was one individual that I had that injured his neck in a paper mill. He was doing blowing some sawdust. The air hose broke apart, startled him. He had a bump cap on, and he raised up and smacked his head on the beam above. he came in and his paint drawing was very non-organic. In other words, it was very, how do I say it in lay terms? It was not to be believed, I guess is how I could say it. And his mannerisms and stuff during my consultation and then during the examination, without going into details, I wish I would have videoed it because it'd be great for a malingering example because they're rare, but this was one. And I contacted, well, it was at the time, this was a few years ago, Willamette Industries, and asked the claims reps there what was going on. And they said, oh, well, this is his 5th injury. I was trying to work with this individual. He was then went to a primary care doc. He didn't like my questioning. This individual went on to spinal surgery, and he was not, and had neck surgery. He was not a surgical case by any stretch of the imagination. I ended up being 100% disabled. And so what happens is, that's probably not a really good example. What happens is many of these cases, we lose them after more difficult disc type cases. And then we lose track of them. And then they end up with poor outcomes. We don't know where they go. We don't know what kind of treatment they get. I can tell you with Oregon Health Plan patients, I've gotten several just this year who have had their claims closed. They have no idea why. They still have the same issue. They got medications and told to return in 2 weeks to the Ahmed clinic and to return again in 2 weeks to the Ahmed clinic. And they have the same problem. They come in under the Oregon Health Plan, it's American CCO, which I'm on panel. And I said, well, why was your claim closed? And they said, well, I don't know. And so we can't stay on top of the cases because of the 18 and 60. Now in the MCOs, it's even worse because I think to the NCOs, we are the attending physician for the life of the claim, but in my MCO, Majoris, I'm limited to 12 visits, then I have to go through the portal and ask for more treatments from the medical director, which is problematic. Many times we get limited numbers and we usually get one return, and then after that, no more, and we lose them. So we are limited. There is no
I'm sorry,
unlimited.
can I just clarify that through a type A provider, it is unlimited if they prescribe that, correct?
I'm sorry, say it again.
Through a type A provider, they can prescribe unlimited chiropractic, correct?
Yes.
Okay, thank you. And is there any way you could turn on your video so we could see you?
Oh, sure.
Thank you. That's
Yeah.
really, I like talking to faces instead of screens. I appreciate that. I appreciate your answer and your response and your examples.
Sure, sure.
Thank you.
You bet.
Another good question, Sarah. Thank you very much. Are there other questions among committee members for Dr. Sabo? Well, we have him on the line. All right. So there is no LC number next to this one, but so we'll see that next time.
No, there's not. Actually, before I go on, Dustin Carstetter has his hand raised,
Okay. Dustin, go ahead and ask your question or make your comment.
Yeah, the question / comment or concern that I would have on this just for consideration is, you brought up, Dr. Sabo, you brought up the situations of, the 18 and 60, how that can be problematic for chiropractors and whatnot. And the suggested fix for that is to bring back full attending physician status for chiropractors. But I also believe you mentioned that it makes sense in uncomplicated cases. If I heard you correctly, correct me if I'm wrong there.
Correct. No, that's correct.
Okay. So I guess the concern I would have is because chiropractors is a bit more of a specialized area of medicine, providing full attending physician status, what happens when a claim goes from uncomplicated to complicated through the course? And I don't believe there's a mechanism in place to switch somebody from a chiropractor to somebody who may be better suited to treat, maybe some additional conditions that somebody has, or maybe something has gone to the level of surgical. And I'm just curious how that would be addressed and whether it would make more sense to try to focus on increasing the number of visits that are allowed for a chiropractor rather than just making them an attending physician.
Well, first of all, in the state of Oregon, our Board of Chiropractic Examiners defines doctors of chiropractic as primary care physicians. We are responsible to cooperatively and differentially diagnose patients, whether it's internal disorders, organ dysfunction, or musculoskeletal, and make the proper referral. Failure to do so falls below the standard of care. So we can differentially diagnose those who are complicated cases that may be systemic visceral pathology that's referring to the back. That's one of our fortes, to catch those things and refer them on. But when I said complicated cases, I'm talking about those who may be surgical cases that have significant neurologic findings that warrant direct referral to a to a spinal surgeon, neurosurgeon, orthopedic surgeon, whatever. But when I said complicated, I'm talking about treating them once we capture them, and we can differentially and triage those cases. That's part of our job as chiropractic physicians. We must be able to triage patients that come in to determine whether or not they're within our scope to treat, or they need to get to the emergency room, they need to get to an internist, to the appropriate healthcare professional, or order the proper lab testing to rule this or that out. Many of us have labs in our offices. So I personally, I'm beyond the 4-year chiropractic course. You can continue your learning. I've completed a 3-year orthopedics program, 3-year neurology program, 2-year internal disorders program, and a 3-year forensic science program. And so that's our job, to triage. But when I spoke in terms of complicated, non-complicated case, I meant musculoskeletal conditions that we're treating.
Okay, thank
If
you.
I may interrupt, this is Matt with the MLAC. I was just wondering, Mr. Kartsteiner, if you're affiliated with an organization or anything like that, if you could let us know who.
I'm affiliated with Washington County Risk Management.
Thank you.
Mm-hmm.
A good question, Dustin. Thanks for speaking up. We are running early, so if there are any other questions, excellent questions out there in the World Wide Web, I would entertain them. Okay, I guess hearing none, we will hear more about this legislative concept at a later time. Thank you, Dr. Sabo, for being on camera. That was a good idea, Sarah. I like seeing the people that we speak to as well. So thank you for going on camera as well.
You bet. I will do so in the future.
All right, thank you.
Okay.
Teresa, do we have other people?
No, but I can speak briefly to both of these concepts. And actually, you did ask, you were in the middle of asking a question about the LC. Yes, so stakeholders can present information, in advance of having a actual draft that's published by Legislative Council. There's actually an overlap. Actually, I'm pulling back the black curtain on how concepts are being developed. Agency concepts are actually, their deadlines for turning in information is earlier than committees and legislators. So WCD's items were been published since, I think, early summer. And then on the flip side, for what's called pre-session bills, the concepts some are starting to come out of Legislative Council, but the deadline is later this year. So that's why this will be more common to have just more of a general conversation versus actually seeing something on
the agenda.
Yeah, in the official LC form, if you will, on that. So I don't know if there's representatives from the Oregon Society of Physician Assistants or SCIU here. If you are, please turn your camera on or raise your hand, or if, I don't think there's nobody else. I know who the people are on the phone. I recognize those numbers. I can speak a little bit about the physician assistant attending status merely because it was mentioned during the second subcommittee meeting. There were representatives from society that talked about this concept in regards to increasing access for workers' treatment there. I don't have any additional information there, but there was prior legislation that was in front of a prior group of MLAC members. It was withdrawn. That would similar to the Chiropractic Association's concept, would raise their attending physician status there. The concept from SCIU proposes to add a PTSD presumption for a set of child welfare workers that work at the Oregon Department of Human Services. So it would, my understanding of that is that it will just add that set of groups to the existing presumption statute that is in place there.
So that would be only for workers that work for that particular department?
That is my understanding, yes. Yes, and I will do my best to get representatives available. I mean, part of it too, there might be some additional conversations that need to take place before they're ready to talk in MLAC, but I will check and see if both, okay, Kristen, if they'll be available for our November meeting.
Okay, I'm excited to see Kristen Adams come forward. Did you have any question or comment?
I just had a question for Teresa.
Yeah.
It's not very exciting, so don't.
Oh, no. This is the time for that.
I was just curious because I know that we've seen the chiropractor bill before in past sessions, and I think we've seen the attending physician.
Yes.
Do you know if they're planning on having fairly similar language to what they had in the past, or if it's kind of a new take on the concept?
From my conversation and the one formal conversation I've had between I think Dr. Sabo is primarily through email. I'll let him actually speak to his LC since he's here. My one conversation I've had with the Physician Assistant Society, I believe it is going to be almost identical, if not identical, but I am not 100% certain.
Dr. Sabo, if you're still on the line, do you know if your bill will be similar to what was presented before?
He might have dropped off. Let me check here. Yes, I believe he is no longer he's no longer a square.
Okay. Great, a very good question. Thank you. All right. Any other questions? Any other comments from committee members as these concepts are brought forward? Is there anything that we would like to tell our administrator as they gather things on our behalf? I don't know.
I do have one comment I will add, actually two. One is actually based on Kirsten's question. As information is available, so when we do have exhibits and such, we will be sure to post those on the MLAC webpage as quickly as possible. Also, for members, we will get information to you as far in advance as possible. We may, actually, just thinking out loud, I know that for our last subcommittee, we did do like a hard deadline of when materials were to be submitted for consideration at a meeting. I may take liberty and have that, so that way there's a definitive time frame for all of you to review materials prior to a meeting. So you don't have the during mid-meeting have to vote or ask questions, things like that. You have ample time to prepare. And also for the department to provide any background information to help all of you in your deliberations.
Okay. Thank you for telling us about that. Is there any other business to bring before this committee?
I do not, actually. What I'm going to do is I did promise to put in a link in the chat to the Workers' Compensation Ed Conference in early November, so I just added that. So that is all I have. Our next meeting on our calendar for the full committee is on the morning of November 10th.
Okay. All right. Any other final comments? I have Tammy Bowers on.
Oh, and Margaret.
Oh, I just was going to ask Sarah, what time is the meeting on the 28th?
It is at 10 a.m.
10 a.m. on the 28th. And so, Teresa or Kara or somebody, the agenda that has the Zoom link, has that already been sent or will it be coming?
We're going to send it out this afternoon. Yes.
Oh, great. Okay. Thank you so much.
Information is there, including the exact verbiage.
Do those agendas go to full MLAC? The subcommittee?
Yes, they do.
Okay, perfect.
Yes. So we use the same distribution list as we do for full committee.
Great.
So like if a stakeholders gets our agendas, they will get the subcommittee agendas as well.
Good. All right. Well, thank you. Margaret, was that your same question? Are your hands up?
Yeah,
Okay,
I
good.
had exactly the same question. Thank you.
All right, good. All right, well, good. Any other items to be brought forward? All right, well, hearing none, I would adjourn the meeting and thank you all for attending and encourage you to attend our next meetings. Thank you very much and have a great afternoon.